Okay, so now we're looking at rights-based litigation and specifically in terms of interpretation. The aim of interpretation of the Bill of Rights is to ascertain the meaning of a provision in order to establish whether or not law or conduct is consistent with that provision. So we're taking the Bill of Rights in their plainest language and using that as a tool for interpretation. Interpretation involves two stages. The first is figuring out the meaning, the scope of the right that must be determined. The second is to determine whether the challenged law of conduct is in conflict with a specific right. The courts have adopted a preferred method of interpretation. The two methods that they prefer over any other, these methods are called the generous or purposive. These are two different interpretation methods. They give expression to the underlying values of the Constitution, being equality, dignity, and freedom. However, there are several approaches, and you will need to decide which one is best, and you're also going to need to substantiate why you feel a particular type or methodology of interpretation is the right one for your case. Okay, so there's textual interpretation. The starting point for the interpretation of the Bill of Rights is the text itself. The text is very important. I've mentioned before that we in South Africa prefer a plain language interpretation of everything. We don't want people to write in fancy high Latin. It doesn't help us. It doesn't help society. So disputes can seldom be resolved with a liberal meaning of a provision. Let's go back to exactly what the text says. Then there's the purposive interpretation. So this is the type of interpretation where you're going to read a section and say, if I read this section in line with the purpose that it was created for, as well as the Constitution, can I get to a constitutional interpretation? The purposive interpretation says, I'm going to read whatever the text is, the offending provision, in line with the underlying principles of human dignity, equality, and freedom. So you should first, what you need to do in this case is you identify the purpose of the right and then determine the value which it protects, and then you look at the offending legislation, or the offending provision, and you see whether or not you can interpret it in line with the protected value. Remember that values have to be objectively determined with reference to the norms and expectations and sensitivities of people. We call this the boni mores. Yes, you were thinking that correctly. So our values do evolve as we evolve as a society, and this needs to be borne in your mind, that norms can change, and then therefore the way that we interpret values can change too. The next type of interpretation is called the generous interpretation. It's in favor of the rights. If we have to give a little bit more emphasis or be a little bit more generous in interpreting the offending provision, that's the generous interpretation. So where it might say only, if we gave it the generous interpretation, it might say only but not limited to, something along those lines. It entails drawing boundaries of the rights as widely as the language in which they are used have been drafted and the context in which they're used. Okay, then we've got contextual and systematic. The meaning of the word depends on the context in which they are used. The provisions of the Constitution must be read in context in order to ascertain their purpose. So, looking at the Constitution, contextually, we know that the Constitution was written in part to address injustices of the past. So when there's a redistributive land right, as contained in the Constitution, then we need to read that in the system, in the context for which it's written. Please remember in all of this that Section 39(1) requires interpretation that promotes the values in all things, promotes the values of an open and democratic society based on human dignity, equality, and freedom. Section 36 makes it clear that rights, I'm going into limitations again here. Section 36 makes it clear that rights in the Bill of Rights may only be used if there are a number of stringent protections that are put in place. Fundamental rights may never be limited. I read you that list of the fundamental non-derogable are also fundamental rights. So there are certain things that the state just can't infringe. You really can never be put into a position of slavery. Anyway, on and on and on. You can see those after Section 39. There's a table in the Constitution. Limitation inquiry involves two main questions, though. Is there a law of general application? And is that law reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom? This is the proportionality test. Section 36, remember, I've read you the list of factors that need to be taken into account. This is not optional. So when drafting your papers for the court to consider, you will run them through your version of the test so that they may interpret the limitation in favor of your way of looking at it. Don't leave that test out of your pleadings. It needs to be in there. So what is a law of general application? The requirement of the law for the law of general application is met if a rule is accessible, precise, not applied arbitrarily, or in a way that discriminates unfairly between persons. Not all laws apply to everyone, but do they apply to everyone in this circumstance? There is law that only applies to employees. There are laws that only apply to juristic persons. But are these laws accessible, precise, and not arbitrarily applied? We say law of general application, but it could be a rule of general application. It could be a regulation of general application, a provision or a policy of general application. It doesn't necessarily need to be codified legislative stature. Then when we ask about reasonable and justifiable in an open and democratic society, to satisfy this limitation test, it must be shown that the law in question serves a constitutionally acceptable purpose. It can't, just because you have a law of general application that infringes a right, doesn't necessarily make it sufficient to pass the limitation test. The law needs to be for something that is necessary to achieve statehood's constitutional goals. We can't have a law of general application that all tax that's payable at the petrol pump goes directly, 1 cent of every litre, or 1 cent of every 100 spent goes directly into a minister's pocket. Even if it's a law of general application and it applies to everyone that buys petrol, it doesn't make it right. That would not cover the limitation test. Okay, so when we go through the factors, that Section 36 1A to E factors, what is it that we actually mean? Section 36 1A is the nature of the right. So not all rights are equal, although we all have equal rights. So the court must assess the importance of the right in context. They're all important, but we can see that there is a hierarchy of rights. So there are the non-derogable rights, and then there are the derogable rights. So the importance of the right, for example, freedom of movement, very important, but a safe environment might be more important. So our freedom of movement was limited to keep us safe and healthy during hard lockdown, arguably. So then we've got the importance of the right on one hand. Then we look at the importance of the limitation. Remember when I was speaking about administrative law and I was talking about reasonableness, where you need to be able to draw a connection between the conduct and the purpose. That's reasonableness. So when looking at the importance of the purpose of the limitation, reasonableness requires that the limitation of a right have some purpose. There must be a connection between the limitation and the reason for the limitation. Justifiability requires that the purpose is one that is worthwhile and important, again, in terms of our underlying values. Where the purpose does not contribute to those values, it cannot be justifiable. again, these are things that you need to factor into consideration when drafting pleadings, when conceptualizing your case. When we look at the nature and extent of the limitation, the court needs to assess the way in which the limitation affects the right concerned. The following questions should be asked. Is the limitation a serious or relevant or a relatively minor infringement of the right? I.e., were your rights limited for a very short period of time? Was it ongoing? Then we get to the question of the relationship between the limitation and its purpose. Right? Going back to that reasonableness, is there a causal link? The law must serve its purpose serve the purpose that it was designed to achieve. If there's no rational or causal connection between the limitation and the purpose it is trying to achieve, then the infringement is not justified. What do I mean by this? The question can be that the state limits your right to access firearms to ensure better nutrition in schools. That would not be a justifiable limitation, because even if one does cause some sort of public good, it needs to be public good for the stated purpose. I hope that's clear. The last question in our Section 36 limitation inquiry is whether or not there is a less restrictive way of achieving the same outcome. This is really actually a question of rationality. And that is when reasonableness is any connection between the limitation and its outcome. Rationality is this the most efficient way of getting there? If there are more efficient, less rights infringing ways of getting to an outcome, then that must be used. If the court finds that, yes, the limitation was for a legitimate purpose, and that the nature of the right and the nature of the limitation balances out, but finds that there could have been an easier way of achieving the same outcome and limiting the right less, then that limitation is also unjustifiable. So from A to E, in order for the limitation to be justifiable, all of these inquiries must lead to the same conclusion. If you miss one, you lose out and the limitation is unjustifiable. Okay, so when looking at rights, very few rights are absolute. We've got our non-derogables, but we also have internal demarcations and limitations, special limitations within rights. Freedom of speech is my favorite one because you have the freedom of expression. That's how it's couched in Section 16.2 of the Constitution. But your freedom of expression is limited. You can say whatever you want to whomever you want, so long as it does not amount to propaganda for war, incitement of imminent violence, or, and this is the most contentious one because there is so much interpretation required, or advocacy of hatred that is based on all of the listed grounds in your discrimination and equality clause. It's a very, very interesting case that came out of Pretoria a couple of years ago, where the question was, is the old South African flag being displayed in a pub as opposed to a museum? In a pub, is that hate speech? Is that protected or is that hate speech? So people that argued that it was hate speech, that it did advocate discrimination, said so, and then people protecting the right to display the old South African flag said something which I think was perhaps the only strategy they could adopt because the case was so likely to fall in favor of declaring the flag hate speech. Contextually, they said that the flag did not constitute speech, that symbols don't constitute speech, that only speech and I suppose written word constitutes speech. I think you and I know where the case went. The judge wrote a really beautiful judgment. I can't remember the citation off the top of my head, but it's well worth looking up. I know it's on SAFLI. The judge said that symbols do constitute hate speech, and that the old South African flag is a symbol that advocates for hatred based on race, because the apartheid system, because the flag is the symbol of the apartheid system, and that because of that, that sort of speech is not protected. This is an example of an internal special limitation, an internal limitation or demarcation of the extent of the right. We don't need to go into a Section 36 inquiry if the right itself has its own internal limitations. Demarcations demarcate the scope of the right by making it clear that certain activities or entitlements fall out of the right. Special limitations authorize the state to make legislation or engage in an activity which may have an impact, right? It may have an impact on the right in question. So Section 22 guarantees that every citizen has the right to choose their own trade or occupation freely. What that means is that nobody else can force you to work in a certain way. Like they can't force you to be a bricklayer when what you want to be is a carpenter. But that also means that you could choose to do any job. However, you can't be a doctor, a medical doctor, unless you go to med school. You can't be a lawyer unless you have an LLB. You can't be an accountant unless you've got a degree in accountancy. These are limitations, but they're reasonable, they're justifiable, and there's definitely enabling legislation that says how different professions come to be. I'm going to pause there, and then the next section is going to look at remedies.